Okay, aloha mai kako. Welcome, everyone, and thank you very much for attending today's Next Steps session about copyright and digitization with Dan Blackaby. This session is the second installment of our digitization series, and the third installment will take place on September 19th, when Clement Bautista and Gina Vergara Bautista will share their experiences working on a digitization project at Hawaii's Plantation Village. And we will be sending out the registration information about that soon. As a reminder, today's session is being recorded and will be posted on HLA's YouTube channel, where you can also find many past Next Steps programs available on demand. And now it is my pleasure to introduce today's speaker. Dan Blackaby is the Reference and Instructional Services Librarian at the William S. Richardson School of Law Library at the University of Hawaii at Manoa. He earned his JD from Michigan State University, and he also has an MLIS from San Jose State University and an MA in History from Cal State Fullerton. He has a rich and varied background working in different types of law libraries, from academic to state law libraries to corporate law libraries. And that all informs his expertise that he is going to share with us today. So I'm delighted that you are here. Thank you so much, Dan, and you can take it away.
Okay. Everybody see the screen all right? Okay. So I'm going to go through a few things. The topic is vast and expanding. So my likelihood of being able to cover everything and answer all questions, not going to happen. So one of the things I've done is my presentation is going to be available as a PDF, so you can print it out and reference it, because I'm not normally as text heavy as I'm going to be in this, but this is one of those things where I think it lends itself to that because it's kind of a checklist in certain ways and kind of pieces of information that are segmented that way. So let me get to the first slide. If I keep wanting to. Okay. So copyright in general, I hope most librarians have a good grounding in copyright. It's a legal protection that was granted to the creators starting back in the 1500s in England to encourage them to, after the advent of the printing press, to be safe in the publication of their works. Because otherwise, if I printed something, there was nothing to prevent somebody else from just copying it. So, and I apologize if you can hear drilling outside there, working there. The other thing is that it controls your rights to reproduce it. If someone else uses it, it gives you a cause of action, a right to sue them, a right to get compensated for it. And in the US, it's typically 70 years, but it varies by country. And that's going to be a very interesting thing as we move into the AI space, as Europe has a very, very different expectation of copyright length, and so does China. So we will have quite a bit of variation and quite a bit of navigation to do as we are becoming more integrated within the AI system. So the first is things that are in the public domain, determining whether or not something is free or not, right at this point. I had a long discussion the other night about Snow White. Snow White is in the public domain. Disney's Snow White is not. It's a subtle distinction, but it's one of those things where you'll see a lot of these movies that are coming out, the remakes, is to preserve that copyright in some way, shape, or form. And so as long as there's copyright on it, you can digitize it. You just can't do anything with it. So you would want to embargo it or maybe keep it somewhere else with a kind of tag on it to check on the public domain status. Because as a workflow issue, it has to be in public domain. Otherwise, you're going to have other copyright issues that are implicated. And once that happens, you're going to have a checklist or workflow that allows your workers to be sure when they're doing this that they are not violating copyright right off the bat. So the other is orphan works. You don't know where it came from. You don't know who wrote it. You don't know if it's proprietary or not. That's another thing that you have to watch out for. There's a bit of due diligence that you have to do looking for possible owners, possible authors before you digitize and put it up on any kind of online display or even as a poster within your library. Um, it's very, very important that you not assume that just because you can't tell that it's free. The other is fair use. That's the other issue, and this is kind of misunderstood by a lot of people. Our students think they can use anything for educational purposes. That's not the case. There are limits. You can't just sit and digitize the entire textbook, which I have seen done. Um, but students don't understand the limitations, and they're not going to be the ones that are going to be on the hook for it when they come and ask us, was our scanner, was your digitization project actually doing that much of distribution, in the sense that I can't just post the book on my content management system and give it to my students that way. There are ways of accessing it, usually through the library. So if I can find something online that it has done that due diligence, I will link to it, but I'm not going to digitize it myself and put it up on my servers because I know that they've done the work. I haven't, so I'll let them take any kind of copyright heat that comes down from it. So YouTubers have gotten a very, very quick uh, lesson in copyright law because of uh, YouTube's policy toward it and certain companies' diligence about doing it. So if you see anything on the internet that's Warner Brothers related, Warner Brothers will go after that person. Some companies don't. They want the exposure. It's a kind of a business decision on their part. But fair use is got its own properties, and it has a checklist to it that we can go into if you like. But the main thing about fair use is that it's not a panacea to everything. It doesn't solve all of your problems. So, okay. Now this is where we're getting into the Gen AI of it all. So Chat GPT, uh, any of those open AI systems, Perplexity, all of these things are using copyrighted material as training data. Large language models will take all of this in and recursively integrate it in so that it quote unquote understands or gets a contextual uh, setup for what that information means. So you're going to have things like New York Times articles, even for our example, law review articles, all of these things will be integrated in. But, you know, I'm still of the opinion that computers are dumb. And so, well, the learning module gets a little bit wonky on those things. The one thing it's gotten bad at is it will not link to that original document, uh, which is their way of protecting themselves from overt copyright infringement. But that doesn't mean they haven't infringed on it, because if you wrote an article, you did not give permission for them to integrate it, but your publisher may have. So, and this goes along with one of the mantras that I see Vicky Simchak's on here that says, if you're an author, check your copyright. You have control over it. You don't have to submit your copyright totally to the publisher. You can place limitations. Um, the web scraping and the way they do that, if they don't get your permission to do it and you still own the copyright, you have a action that you can perform. But if you do give it to the publisher, you're kind of, you miss the boat, because as long as the publisher has the right to sell their corpus, you're going to be included in that. Right now, it's not as bad because you don't get the overt display. It's kind of underneath the hood, but it's going to get to the point where we're going to be able to say, show me an article about this, and they'll produce the article. It's not there yet, but we're getting there. The other thing is that they're going to try to use fair use as a way to get around that, in the sense of, if every OpenAI query is an educational query, they're going to say we've got coverage under that. That's a little bit that's pushing it, and I'm looking forward to seeing that challenged. There's also the scale, because they're doing this on a scale that is beyond what has ever been attempted before. A few years ago, Harvard sold their back issues of the Federal Reporter. It was probably, I want to say, took them 2 or 3 years to do the whole thing. And it was a massive amount of case law. Now, technically, case law is not something that's copyrighted, but all the surrounding things are. So, say like the title, the commentary, even the font. So that gets into a little problematic. Is like they have to rip the text out, so it takes them a little bit longer, but they have to basically make it style sheet neutral for a lot of these things to work. Now, there's different laws in different countries, like I said before. For example, I think Peter Pan, if anybody knows the story behind that, the author of that, he gave the copyright to a children's hospital. And so the UK has just not chosen to enforce a ending period on it, simply because it was a charitable donation. That's a very rare exception. But the European Union in general is far more protective of the rights of the author. And they will make it very, very difficult if you are trying to make a derivative product without going through the EU checklist. And given the fact that Google, even Apple lately, if you've noticed, Apple, you've had to change your kind of charger from a lightning charger to a regular USB-C 3. That's because the European Union made them. So the European Union carries a big stick when it comes to these kind of regulations, and big tech companies have found it easier to conform rather than to fight it. So most of these things will come in passable under the EU law at a minimum. So the output, how does it look in terms of what ChatGPT or what OpenAI puts out? They don't remember very much. So if they if you ask something that is specific enough, it will actually reproduce the entire article, the one thing it has in its learning model on that subject, verbatim, word for word. And it's obviously a direct copyright infringement, but that does not play with the way their model works. So it's a matter of trying to adapt a very, very large model to a very, very small issue. And they haven't quite done that yet. The other issue comes up with derivative works. And this is more on the generating, say, AI art. If I make say, I want a picture of Elvis wearing a tutu, and it makes it, I might have the people in Memphis coming after me. You would say, okay, we control Elvis, the image of Elvis. But as it turns out, they've actually already taken steps for this. So if you try on Dolly, or if you're in Canva, you can try this on their generator. If you mention anyone of note, any kind of famous person, any recognizable um, person who has an interest in their own image, it won't produce them. So you can say, I want to have a picture of Richard Nixon doing something. It won't produce it even though he's dead, because his estate still exists. So they will have that interest. And I've seen it go as far as talking about Lord of the Rings, because Tolkien's estate is very on this. So most of the way that the companies are getting around it is just to not do it. They're cutting it off and saying this is the standard. We're not going to deal with that, because they don't want to be dependent on random people getting them in trouble by making images. So they've just cut it off of the needs. Um, then you have authorship where nobody created it. Um, so AI isn't a person, right? So it can't have a copyright itself, but most of them are also corporations, which can hold copyright. Um, so you have to think, okay, is it owned by a corporation? Is it owned by the underlying owner of the image that it's based off of? Or is it a public domain thing that it's never existed before? Now it exists because AI created it, and this particular iteration of it in particular. So I can do lots of pictures of dogs playing poker, but this one specific AI generated one is different. So automatically it's a different manifestation. So it's a different copyright that you would have to track. And U.S. Copyright Office has kind of bailed on it. They're saying anything that's produced mainly by a machine can't copyright it, which is kind of interesting when you get into uh, things like ready-made printing presses and publishing ready software. Um, but the UK is the only one that I know of that has found any kind of solution for this, and they're attributing it to the person who made the arrangements for the creation. And one of the reasons they do that is for issues like Banksy. Everybody know who Banksy is? He's kind of a random rogue artist that goes around uh, painting random things. Lately, it's been animals on things, but his work is very valuable. But no one knows who he is, so therefore, how do you assert copyright when you are anonymous? But they do know who works for it, so they know that there's this kind of group, and so the copyright is assigned to who makes that image possible rather than who makes the image. If you do it here, you would think, okay, what would be the application in Hawaii? Well, let's think about the things that you could uh, apply this to. For example, hula. The different iterations of hula are different pieces of art. They're all one content in the sense of they're going back to the same medium, but they're different art pieces. So that they could probably say, okay, you can copyright this particular dance, but you can't copyright hula in general. That, everybody clear on that? So that's how a lot of the UK and some of the Nordic countries are treating this by saying, okay, we're not going to copyright the image itself. We're going to copyright the methodology or patent it actually. Uh, so that therefore it doesn't matter what it spits out, it's still covered under the copyright of the person who made the machine that created it. That's their way out for right now. So when you do have public domain materials, first thing is find out who has the copyright. Now, I tend to think of the digitization measures within the library as a workflow issue, in the sense that if I get a box full of things to be digitized, I'm not going to just start dumping it in online. I'm not going to just digitize. I want to go through and record my decision making process and record why things are done the way they are. It helps with the kind of having a person associated with this project that knows archival cataloging, so therefore they can do some of this investigation. So you'll have a checklist. Is it in the public domain? And it's like, you have to go through that. It's like, well, yes. And how do I know this? And you would check that off. And basically, the best practice on this is just don't even, before you even get near a computer, figure that out because you don't want to waste worker time. You don't want to waste server space. If it's going to stay in the box, let it stay in the box. The same thing with the orphan works. You want to have that as a check mark. Is like, do I know where it did come from? Even if it is in the public domain, I need to check, do I know the origin? Because that way you can do what attribution you can do. Um, and it's getting better in terms of like how much you can use an orphan work in terms of the legality of it, simply because there's so much being produced now with the age of computers. Um, when you use fair use, it's the makes basically it's like, what are you doing with it? Now, the open AI stuff, there is no dedicated purpose for what they're using. I could have my 13-year-old niece sit down there and she's using it to make pictures. And then I could have, your 80-year-old uncle doing the same thing, but he's using it to find, uh, you know, codicils he wants to attach to a will. In the sense that the purpose of the AI is open. There is no determinative purpose for it. There is for your projects, in the sense that when you are digitizing something, do you have a purpose? Is there a project that it's going to? Is this for preservation purposes? Or is this for distribution? Are you going to turn it into say, a coffee table book or a pamphlet? Or what is the point of digitizing what you're doing? And that's going to impact whether or not you can use the fair use doctrine, in the sense that if it's totally commercial, you're not going to get fair use simply because that's not the point of it. of the fair use doctrine. Fair use doctrine is to allow for reasonable use without having to go through the entire checklist every single time you want to use something. It's a limitation put in place beforehand so you don't go off the deep end without looking. So think about, okay, am I doing all of it? That's a problem. Never do all of something because fair use does not like, completists that way. Uh, it's You'll hear percentages. It's going to vary by different formats, what you're doing. Um, Say if it's of a textbook, I've heard one chapter, I've heard 10%, I've heard 20%. It varies, but it's a judgment call ultimately that you're going to have to make about whether or not this fits that criteria. Um, and you'll notice that a lot of purposes, so I don't know how many of you are in academic schools, you'll have faculty who want the material digitized. And so the point is, well, what do you want it digitized for? Do you want it just so you have it? Do you want it on a public online forum? Do you want it preserved in a embargoed uh, archival database? And sometimes they'll mandate it in the sense that I've been at schools before where people who write a thesis don't have a choice whether or not it goes onto the archival database. They do have a choice on whether or not to embargo it and say, okay, I produce this as work product here, so they have the right to it, but not for 5 years, so I can maybe make a book out of it or publish it use it some other way. Um, and what that does is it kind of puts it in a box on the site. It's like, yes, we have it, but you can't have it yet. It's kind of a tease. But it also lets you know what the rules are around it because when they do have an embargo, it's pretty explicit what the rules surround it. Let's see. Okay. If you're going to have any kind of foreign materials, you have to check where it's from and what the copyright and uh, rules are in that country. Um, Trying to assert copyright in China, for example, is highly difficult. That's why you'll see a lot of bootleg movies, a lot of uh, kind of discount. It used to be DVD players uh, that you could get that were not going through the copyright system or going around it. Um, as I said, Europe tends to be more protective of the author. Uh, U.S. actually is kind of in the middle in my opinion. Uh, you can have some that are just like you don't really play with the Nordic countries because they're very, very protective of their authors because take great pride in it. Uh, so a lot of that material and a lot of government material, that's a that's even odder because that's done for hire. So there's part of foreign government material that's going to be copyrighted, part of it is that's not. And you're going to have to wade through that if that's something you want to put on. But if I'm dealing with like a faculty or a donation of papers, the one thing I want to do is look at my deed of gift. Because usually when you get a donation of something to go into the archive, it comes with a deed of gift telling you, do you own this now? Or is it on loan? Or what are the rights of the person donating it? Can I uh, publish derivative works? Can I display it on archive? Do I have to wait 20 years until the person's dead in order to release it? There's all sorts of things that you're asked of in archives that don't come up in normal daily library in that sense. And that deed of gift is really your guideline to what instructions a person has for you when it comes to how to do this. Uh, um, but if you want to do it, see examples of them trying to do it at a large scale. The Google Books Project. How many of you have ever looked up a book on Google Books? Yeah, you'll notice most of the time you can't get the whole book. You only get a part of it. And that's them conforming to the fair use doctrine, conforming to the restrictions that copyright places on it. And sometimes that's even, it'll be something that's 100 years old, but the idea that you have to, that someone is going back and turning a switch to turn it from protected to public domain, that's a lot of work, especially given how much they're trying to digitize at the time. They there is the Europeana database over in Europe that helps you kind of work through this. It's like, can I do this? And I usually will go there because it's more restrictive. So that way I know if I meet those criteria, I'm going to meet the American criteria. So it's, you want to go with the stricter interpretation. Um, so this is going to sound like a lawyer mantra, but do your due diligence. That is what copyright and digitization, because you are creating something and you are put in stewardship of something. So you want to make sure that you have the ability and the permission to use the content, because the content of the material is one thing. The actual physicality is another. By digitizing it, you're making a third manifestation. So you have some control over, say, the metadata that goes into it. So there's levels of copyright and display. So if I were to put something on my site that had a big New York Times watermark in the corner, I kind of know that I took it from there. Did I get permission from the New York Times? That's another question. It's possible, but the thing is, you kind of assume it's not. And that's where things like Creative Commons and public licensing come in, so that it gives you the option to use things with the safety of knowing that someone has done this work or someone has positively asserted that this is open access or has set certain limits on its use. Um, that's kind of a, you know, we can't know everything about everything that was ever produced, but we can start to say, okay, when you make this, decide then what you're willing to do. And more people are doing that in terms of academic articles, in terms of artwork, in terms of logos, all sorts of things like that are becoming more and more. You'll see the open access symbol more than you thought you would, especially in the journals, because it didn't used to be where you would see that at all. Like, I don't know if any of you have ever been in Elsevier, where you have to pay like $400 for an article download. But they have very little open access. But if you go into EBSCO, they've got a fair amount. And the reason they do that is it is a loss leader, in the sense that if they know that their users are aware of the open access material, they'll go to the database and see the other material. So it's kind of like a sample at Whole Foods, in the sense that it brings you in and you can say, okay, I like these articles, but there's this one and it's only $30, so maybe I can splurge for that. But you wouldn't have seen it otherwise if you hadn't followed the open access path, because the search engine optimization actually looks for that as a particular factor. Because if it's not available to you, I don't know how many of you tried to get into a database you don't have access to. It's going to kick you out, but a lot of times the open access things are available even if you can't get into the database. They'll come up in Google, they'll come up in different searches. Um, let's see. I've got a lot more slides, but I want to make sure that I'm doing okay on time. Um, the main thing from a legal perspective that I would prescribe is to document your decisions in the sense that you do a lot with digitization projects. It is a large, hard endeavor to do a big digitization project. So those day-to-day decisions that you're making, come 2 weeks from now, you don't remember why you decided what you did. But if you document the reasoning for it, it not only tells you how you were thinking, allows you to be consistent, but it also lets other people understand. It's like, okay, let's say Brian decides he's going to make this into, uh, he's going to do it under fair use, and this is how his rationale for it is. That is a lot easier than trying to guess at what somebody was doing. It also lets you say, okay, have you looked to see if someone holds copyright? Have you looked to see if there is a proprietary extension of it? Like Walt Disney is, despite what the conspiracy theorists may say, he's dead, but Mickey Mouse lives on, right? So that means the copyright moved to the company. So that kind of things, copyrights can transfer. And while I don't have the link in here, one of the things you can do, or simple things, is go to copyright.gov and put things in here there and do a lot of interesting searches on what is copyrighted and what isn't. Um, my favorite ones are like when you look up athletes, they'll have their nicknames on there, like King James for LeBron James. He's copyrighted that. And you're like, well, what about the King James Bible? They made it, it's reasonable copyright. It's not total. So that's one of the things that you have the ability to do is to do a kind of initial check. And that doesn't have to be done by uh, the archivist alone. That can be done by staff. You can have someone who's in charge of processing the boxes where that's what they do is they fill out these kind of justification forms. They fill out what it is, what limitations they're under, and you can direct them to say, okay, if this is in this pile because we know this is copyrighted, so we're gonna keep this over here. And usually that material um, can wait because if you're looking on these projects, people want to see results, right? So you'll get the stuff up that you know that you're safe putting it. The other thing to remember is you too have copyright once you digitize it in the way you format it and display it. So there is an extra added element to that in the sense that you are creating your own copyright. Um, so be aware of that. Let's see. Also, and this is something that may sound self-serving, talk to a lawyer. If you have any doubts, talk to somebody because these decisions always need to be kind of hashed out because I can rationalize using something in my head. That doesn't mean it's correct. That means I need to make sure that everybody's on board with it before I go forward, if I have any doubt at all. Um, and you'll be surprised how many people will give you permission if you just ask them. Oh, I've got somebody knocking on my door. Um, he's trying to get in. Um, so in that sense, it is a matter of kind of just being mature about the whole thing and doing your due diligence. Okay. Uh, he literally tried to just change my lock. Okay. So let's see what's next. Oh, and as a librarian, you do have a point of view on this, and you have an advocacy position. Um, I know HLA has an advocacy committee. I think I saw Crystal in here, who's on that. You want to, if you have an interest in protecting, say, Hawaiian native cultural copyrights, or you have an interest in protecting the, say, young authors who are making books and trying to do that kind of work, you can do little workshops with them and say, okay, you have the right to this. When you make this, this is yours. So make sure that you know what is yours and what's not. So I've seen it given to kids who make comic books. So they know it's like, okay, you can do this, but that's a little too close to Spider-Man or something. So you might want to change this up. And it's fun to do, to kind of walk them through their creative process. But the other thing you have to be aware of is because of this Gen AI stuff, it's changing. It's going quick. And there's really not going to be um, any kind of limitation until there is something that is forced. In the sense that the New York Times and I think it was Newsweek sued Google on the basis of the OpenAI materials and the material that went into the large language learning model. I know the comedian Sarah Silverman and Margaret Cho have both sued because they said, okay, my performances were integrated in. I didn't give anybody permission for that. And they said, well, HBO did. And they're like, HBO didn't have the copyright and you didn't check. So it's one of those things where the inertia of these large companies makes it to where they're not doing the due diligence that they need. That doesn't mean you should not do it either. Because I don't know about you, but I don't want to hire as many lawyers as Google does. So it's really a matter of what do we want the copyright system to look like, and how is it going to respond to these changes that are not really instinctual, because we're able to do things now that when they created copyright back in 1536 with the Statute of Anne, they never contemplated the idea of uh, you know some random person creating a picture of me doing something just by saying a few words. They it's just a new world, and our speed of technology development is making it hard for copyright to keep up. Uh, but they're trying. So it's 12:46. Do we have any questions?
Yes, if there are any questions, you can feel free to put them in the chat or feel free to unmute yourself and ask.
Okay. Brian Huffman has put some very interesting things in. There's an ACRL guide linked. Um, it's Copyright's one of those things that can sound scary, but if you get into the kind of rhythm of doing this as a matter of process, it becomes kind of rote, in the sense of like, do you have the copyright, you know, checklist done yet? No. Well, we can't digitize it yet. Then they'll say, well, we can make the files. It's like, yeah, but then where are you going to put them? So it's so sometimes that you will see people that have files that are basically designated not to be published. You know, this is off limits. The file exists, but it's not used for anything. Because if there can be no use, there can be no fair use violation. So if you just keep it on your laptop for, and say personal use, you can probably do it. But if you're trying to distribute it in any way, that's where we get into problems. Okay. Jody wants to know, could I talk about copyright recorded music and musical performances? Okay, the thing with recorded music and musical performances, and this there was a very interesting case just I want to say in the last few years with what is it, Ed, the redheaded Ed guy, whose name I can't remember. Uh, in the
Ed
sense of,
Sheeran?
yeah, Ed Sheeran, yeah, he because he was sued uh, by the Marvin Gaye estate, and so was the people who did. I want to say it's Robin guy on,
Robin Thicke.
yeah, Robin thing. They're very proactive about suing because the thing is, for the music itself, what is it that you are actually copyrighting? Is it the song, the actual, say, notation, composition, the arrangement, the voice, which is getting even more problematic now that we have AI voice replication? You don't have anything there that says, okay, this is the magic bullet for music in terms of what is copyrightable, because it, in some ways, it all is. Because if say, I I'm Celine Dion, I've never said that before in my life. Uh, if Celine Dion sees somebody imitating her, that gets a little different because are they a tribute band? Is it an homage, or are they directly ripping her voice and style off without any attribution or acknowledgement of the fact that yes, I'm obviously copying something? That's how you can get away with having Elvis impersonators and uh, a lot of drag queen lip sync competitions and things like that because it's done in parody slash homage to these celebrities and large figures. So it's not really intended as a commercial enterprise. But if you are selling, uh, say, Jody, you come out with an album next year, okay? And you are song for song redoing the latest Taylor Swift album. She might have a problem with that, in the sense that that is a, um, that's you basically saying you didn't ask me to do this. Now you could ask her if she could give you permission. That's what cover songs are all about. But if you cover something and you don't give money to the person who produced it, they have a right to come after you. And the same goes for anytime you hear something on television in the background or in a commercial or the Friends theme. Every time a rerun plays, the Rembrandts make a ton of money because they have the rights to that theme, and every time it plays, they get paid. And the reason is because they own copyright in that song and in that particular performance of the song as well, because that is also allowed in the sense that performing, say, live on stage, that particular manifestation and that recording has different aspects than the underlying musical recording. There's a visual component, there's a uh, active dialogue component, there's all sorts of things that are different and copyrightable because the event itself is a different kind of material than the underlying song. It's kind of an added package. The song is incidental to the larger event. So if I try to use the Olympics closing ceremonies, I got a problem there, even though I might have the rights to every song within it. Was that too much? Okay. Anything else? Other questions that I can answer while I'm here? Answer.
Dan, I'm going to burst in here and ask if you have anything to share about controlled digital lending, which is something that our library has dabbled with, but it's kind of in I guess, a murky legal standing.
Yeah, you'll see the Georgia State case comes up a lot in the sense of, and this kind of extends out from the DRM, digital rights management aspect of it, both pro and negative, in the sense that I don't know how many of you remember if you had an iPhone, suddenly you had YouTube's latest album on your phone and you didn't ask for it. That's kind of a proactive digital rights management. It's not really lending, it's forcing. But the controlled lending for, say, through things like an online book distribution, so being able to check out particular copies and have it expire, that is a median way, and it's proven fairly successful way of controlling access while still retaining that kind of control over copyright and use. In the sense that and it depends on what you're looking at, because some things, yeah, I have controlled lending, but it lets me download the PDF, and I always had a PDF, so that's not really controlled lending. That's just giving me access to it so I can copy it. The control lending, a lot of the file formats will actually let them turn off your access or password protect it, to where you have to have bought a license in order to access it. Most of the people's experience with this will come up with various software licenses they have to buy in order to install it on their computer. Or I've even seen it with a tax preparer, in the sense that that's the only way her clients got access to the documents, was if they were able to produce a self-identifying number that would meet the criteria that was assessed. So that it was a privacy protection mechanism. That kind of material has a kind of a weird interstitial space, because if you read something on Kindle, you don't own it. They say you do, but you don't. Because while I could technically get the material off of Kindle if I really tried, that's not the same thing. I'm creating something new. I'm making a different kind of copy, because they're going to have it in a controlled DR. The EPUB version they have is going to be very distinct. You'll notice their file formats, I think it's MOBI instead of the EPUB. So it carries that digital rights management executable within the file format. So if you see EPUB, it's most likely you can do whatever you want with it. But if it's MOBI, you don't have any control whatsoever. They can take it back from you at any time. You're buying a license to read it. You're not buying the book.
Does anybody else have any questions about digitization projects, and any copyright questions that you have about approaching those projects?
Okay. Like I said, I did not get through all my slides. and you can be thankful for that because it keeps going. But I do have posted the PDF, and they have it available for you to look at. And a lot of it's just going to be checklists, best practices, you know. So main thing, do your due diligence before you start, and check your deeds of gift for if you get donated papers, is they'll tell you what they want you to do with it a lot of the time. They'll say, oh, I want this put on public display, or hold this for 25 years and then release it. So you'll get that with authors a lot of the time. Their personal material. But just, it's one of those things, it's not a simple put it through the scanner, put it up. No one else? Thank you for taking the time. Is there, because I think we have another 15 minutes if you want to keep talking.
Yeah, thank you so much, Dan. And the link to the slides is in the chat if anybody missed that. And it will also be in the YouTube description when we get this video posted on YouTube. But thank you so much, Dan, for all of your sharing your expertise with us, and on such an incredibly complicated topic. To condense it down to 1 hour is really an admirable feat. So thank you so much. And thanks to all of you for attending. And we hope to see you on September 19th at our next step digitization series 3rd installment. So mahalo, everybody, and aloha.
Thank you. Oh, 24 new messages. Okay.